We're glad to welcome all of you, dear viewers. Excellent conference, and we have a wonderful panel dedicated to who will hold the IPRs on AI-supported or AI-generated works. When we're speaking about AI, when we're speaking about the artificial intelligence, we understand that very often we encounter an opponent, not a person who is equal to us. Today at that session, I'd like to discuss the questions related to the copyright or authorship for the products of AI. Who has to be the author of that product, the one who provided the algorithm for the data, who actually created the process? We'll speak about some criteria to determine the rights holder of such objects, how to assess the contribution of each participant. We'll speak about the registration of such works, how it should be done, and also we'll speak about the rights infringement. Let me draw your attention to the fact that today this panel is quite unique. On site are two outstanding colleagues. On my left, Ruslan Budnik, professor of the Copyright, Mixed Rights and Private Law Department of the Russian Academy of Intellectual Property. On my right, you may see a representative of Yandex company, head of the legal practice in the area of software, brand transactions and Yandex data, Alexander Gavrilin. But this is not it. We have more speakers to attend our panel, and I will introduce them to you one by one. All in all, there are 7 speakers. So I'd like to ask our speakers to be brief and concise. Please stick to 8 minutes time limit so that actually we respect the rights of the co-speakers. And so that I'm glad to pass the floor to managing partner from Denton's office in St. Petersburg, Viktor Naumov, who is present online with us. I will not list all his credentials, or at least it will take more than an hour till the end of the session, because he's an outstanding specialist in the area of artificial intelligence. Victor, over to you. Thank you so much, Natalia. You made me shy, because it was certainly a flatter what you said, but the presence of such outstanding panelists makes me look at the topic at hand in a very detailed manner. I realize that not only me, but even colleagues may run into some technical problems, because I can hear the English channel as well, just for the notice of the organizers. Probably we have to adjust something. But nevertheless, let me continue my presentation. Can you hear me? Yep, we do hear you very well. Thank you so much. Colleagues, I'd like to thank the organizers, Rospatent. I'd like to thank the moderator for this opportunity to speak up at such an interesting session. I'd like to draw your attention to several key questions which, in my opinion, have to be considered in the context of AI regulation and IP rights. But at the same time, let me note that the first problem is not legal. I think that the mankind is facing very difficult conceptual questions related to how we treat what is being done with AI and what we do about a strong AI technology in some foreseeable future. The answer to that question should be obtained not from lawyers, but from the civil society, from the experts in different domains, starting from psychologists, futurologists, sociologists, etc., as far as the changes which are taking place nowadays in the human society, especially amid the digital transformation, will dramatically change not only the legislation and not so much the legislation, but would rather change the nature of relations and ways the mankind develops in the upcoming future. In the context of our niche question related to the creativity and rights holding in the area of intellectual property rights, it may seemingly be quite easy when we have to choose the model for regulating the IPRs, and to simplify that, due to our jobs, due to our stereotypes and concepts, we can put that question for referendum, and we may say that AI in future will become an asset or quasi-asset. It will have some agency or will not have an agency, or should not have any legal personality. And by means of voting out of a limited number of options regarding this or that regulation model, we would generate certain solution. And let me draw your attention to the fact that this is not a legal choice. This is a choice to be made by civil society. That's a very difficult, philosophical choice. If, for instance, we regard the IPR as or artificial intelligence as their subject or object of the rights holding, or if we delegate the right to AI to the authors of certain programs or software, what will happen to a man as a creative person who will have certain reference indications in all the legislations in the world? In the Russian Constitution, we have 3 articles dedicated to certain aspects. Very briefly, the Constitution speaks about the freedom of creativity and the right to create, to invent. But what may happen if, for instance, we have massive rights holding without the author, where actually, once we speak about the machine learning, actually, the system probably will not be protected at all. This is not a legal topic. Everything will have to be assessed through the prism, through the deliberations of how it may impact the basic human rights, the trajectory of the development of the mankind, not so much the economy. And certainly we have to look at that in a very niche, creative, intellectual area. Against, well, actually, along the lines of the discussion whether a man can be regarded as a hybrid entity, this topic looks much easier, simpler. On the one hand, that's an easy topic, but at the same time it has to be addressed in the framework of a very complex discussion and debate which takes place all over the world. IPR protection and the need to solve the problem of rights holding to the AI-driven technologies. It's been enshrined in multiple documents, starting from G7 to certain nation-states, such as Japan, for instance. Japan has issued a declaration saying that this problem has to be addressed. If we go further, if we look at the judiciary practice, and our foreign speakers are going to speak on that, along with our colleagues from Russia, we see there would be a clear-cut enforcement model in the Anglo-Saxon or continental rule systems. In Great Britain, this area can be regulated even in absence of an author. India offers the same structure. There are some precedents, some cases in different countries, ranging from China to the EU. The same is true of the UK, although this is not a massive, large-scale inflow of cases, and still we see that the courts find it difficult to take a uniform approach to such cases. Certain precedents certainly will be described and characterized by colleagues, and therefore we'll have to make a very difficult choice, a very tough choice, and we can follow certain criteria. The simplest approach is once we define what an artificial intelligence is about, once we actually define that as the object of right-holding, and probably we'll have to look at a more sophisticated category, whether the artificial intelligence which functions and which is created by a man, such machines are too far away from creativity. If they are too far away, and if there is an intent by a creator to generate certain programs, certain software, and it results in something which is devoid on certain creativity and has no author, this would be scenario number one. The opposite scenario would be once we have the artificial intelligence technology which is used as a classical tool for processing the data or information with certain originality. For instance, we take a graphic editor and we do some tuning there, and it would simplify the creative process somehow, or assist the creativity. And in the third case, actually, the situation would be more mundane, and this problem is being addressed by the judicial practice as well. If we look at the guidelines in certain documents, enactments in the Russian Federation, for instance, a decree by the President of the Russian Federation and some strategists, we'll see that there are no direct answers to these questions. And therefore, everything is left for the discretion of certain courts and the judiciary. But in my opinion, these are not lawyers who have to choose the regulation models, but we have to enforce the decisions taken by some interdisciplinary bodies, because we have to calculate psychological, economic, and social consequences and effects. For lawyers, that would be too different. Certainly, the regulation and law enforcement practice should incorporate the basic legal rules and principles, which will be guided by the principle of fair practice. Objectively, AI-based technologies should not infringe the common set of rights and rules applicable in the human society, and should not restrict the access to knowledge. And another thing, the last thing I would like to note, we all understand that digital transformation is implemented by the business, by the companies, for some commercial purposes. And therefore, in the interests of the educated persons, we have to protect these entities as much as possible. We'll understand that they are part of this scientific progress and revolution, but the commercial interests are prevailing, and therefore big business may lobby their interest, and certainly it would impact the choice which certain countries will have to make in terms of the pieces of legislation they are to adopt. If we create certain or offer certain exceptional conditions for businesses, we may come up with a situation, we may end up with a situation when the path breakers would create certain technological solutions, and then AI and AI technologies will become will create certain products for the mankind, and the mankind would lose another opportunity to tell what is being done by a man and what is being done by AI. And therefore, mankind would lose any motivation to invent something. I understand that my deliberations are purely abstract, so I will be glad to continue some practical things. Thank you so much for your attention. Thank you so much for setting the tune, and I'm passing the floor to Matthias Hoffmann, who is co-chair of the ICC Artificial Intelligence Working Group. He is principal associate from Freshfield Bruckhaus Deringer. He is present with us online from his office in Vienna.
Und bitte 8 bis 10 Minuten.
Many thanks. Hi all again, and many thanks for the kind invitation. A really exciting topic to discuss here. Just as a disclaimer, I had some issues, unfortunately, to understand all parts of the earlier presentation. So I appreciate we might discuss later on. Again, I would like to give maybe some insights as well. We had as ICC working group, which is a quite diverse group within the IP commission of the ICC, when we took part in the WIPO conversation, where a lot of the questions you addressed in the agenda were obviously quite intensely discussed. And I think I agree that this is, in any event, not a pure legal question, but a policy question. But I think as a starting point, it was also discussed in various WIPO conversations that the current framework should be tested quite robustly, whether and how AI as such and both AI work products or works are actually already protected. Not necessarily, strictly from a copyright perspective, or from a patent perspective, but from a broader contractual protection as well, or even on the unfair competition regimes. And I think, also in my personal opinion, I think this would be very helpful for any policy discussion to make a robust assessment on how AI lifecycle as such is already covered by the existing framework. And then as a next step, to see whether there's some deficits in this existing framework. And this is then actually the policy question, whether the deficits are severe enough to be actually addressed by, let's say, new amendments from the copyright regime. So this just as a starting point, and actually this is also my personal opinion that this is very helpful for guiding the discussion. When we go into more details, especially on the copyright aspects, I think in the WIPO conversation, the majority view was that obviously a fundamental question is whether AI-generated works should be protected at all. And during the discussion, it became quite obvious that you have to distinguish between AI-generated works and AI-assisted works. And I think what also became quite obvious, at least this is also reflected from my technical understanding, that we don't have a software or AI system available as of now, which actually is able to act entirely autonomously and create create works by itself without any human intervention. So I think one outcome for us as a working group, and I think this was also the majority view in the WIPO conversation, was when we talk about AI and AI work products, we're probably talking right now in the sense of a narrow AI, which is always assisted, guided, used by a human in the end. And I think with that angle, especially in the copyright system, I think we have quite a lot of tools available to capture such AI-generated works, because ultimately, from a European point of view, you would require a human creator who must somehow, or the work of the human creator must somehow reflect the personality of the creators. This is like the well-known InfoPack decision of the ECJ stipulates this principle. So if we are not talking about entirely autonomous outputs, and my personal view is we are not there yet, we can basically use this framework and use this test to see whether the human intervention when using the AI tools and generating outputs is sufficient to avoid copyright protection, as an example. And I think what's also important to highlight, there are even as of now some legal regimes, like in the UK, which already awards copyright protection for computer-generated works. So already in the existing frameworks we see around the world, we have some tools at hand where we can allocate these rights under the existing IP regime. So the question to me is not really, is the problem entirely this autonomous AI, because I believe we are not there yet. But the question is, how can we use the tools we have now to allocate the rights? And I think when we use those tools, we are also able to solve the questions, whether the algorithm developer, the information provider, or a person who used or trained the algorithm is an author in the sense of traditional copyright or creates an invention under the patent scheme, because we always can apply the test, was the contribution of the person at hand really relevant for the conception of the ultimate work product? So I think the framework we have is actually quite robust and quite technologically flexible, and I think this should not be forgotten in the discussion. One outcome though was whether actually we have to discuss whether the existing framework limits AI, especially the use of training data for machine learning systems. And I think this is in particular a very interesting question, because you can obviously make the argument to say, look, I cannot use machine learning without a large set of data or deep learning. And if the existing content is very heavily protected by existing copyright regimes, this will hinder actually the further facilitation of AI. So I think a second conclusion for me, and this was also highlighted in the WIPO conversation, is to take a bit of a holistic approach and see whether actually we don't have a need for further IP rights, but whether we may need to even tune down existing IP rights to accommodate for the need of training data or free flow of data. So I think this is also one aspect which should be not forgotten in the overall discussion. And in terms of the questions how AI created works should be registered, I think this is maybe a bit of a more technical question. If we have answered whether these works fit within the existing scheme, or whether there is something which really falls beyond the existing scheme. From my point of view, this is maybe relevant when you talk about, you know, patent inventions, AI patent implemented inventions, where we talk about disclosure, whether we need to, you know, fine-tune the disclosure requirements and stuff like that to accommodate for disclosure of training data and so forth. So in a nutshell, I think we have a very robust worldwide framework, and this allows quite some flexibility for the AI work products we see right now. And from a policy point of view, I think we have to consider whether the existing system is enough, or whether the AI we are currently looking at is really that advanced that we're talking about fully autonomous AI, or whether it's just still a highly sophisticated, obviously, but still a tool in the end, which then can be fit into the existing regime quite nicely, I think, with obviously some details which have to be resolved, but from a dogmatic approach would still be a good fit for the existing system. So with that, I would hand over to my colleagues.
Thank you so much, Matthias.
Thank you very much, Matthias. An excellent contribution. You gave us an international perspective. And now I would like to give the floor to Representative Yandex, Alexander Gavrilin, Head of Legal Practice in Software Technologies and Branded Data Transaction Yandex. Yes, thank you very much. Thank you very much for this opportunity to speak in this trust patent conference. I would like to focus on the issues raised by the fact that neural networks create various works, and I'd like to offer a balanced approach to legal protection. First, a question. Do we need to provide any legal protection to assets created by neural networks? And before we find a balance, let's look back into the history. As we all know, to justify legal protection by means of copyright, we rely on a number of theories, and there are problems with any of these theories when we start using these theories with respect to works created by neural networks. First, the theory of encouragement. We believe that copyright protects the rights and personality of the author to encourage the author to create new assets. Problem is that the computer does not need such encouragement. Two is the theory of natural rights. The copyright is there to protect assets, to keep them, to help them exist, but there's another problem. At the moment, a computer is not a person of law, so it doesn't need any protection. And last but not least, the theory of remuneration. The authors, creators should be remunerated for their work, and this is what copyright is there for. Again, a problem. Computers don't ask for any remuneration to create anything again and again. So as we see, the current theories of justification don't quite well suit the reality we're facing. Now, let's cover very briefly the main approaches to patentability. My colleagues have already discussed this today. I'm not going to dwell on it in great detail, but basically there are three main approaches. The first one, shared by most of researchers and practitioners, is that AI is about a computer. It is not a personal law. It cannot any rights. It's just a tool. Only various persons of law that interact with this AI can have these rights. Second approach, a hybrid approach. AI is assigned a certain extent of rights and also has certain rights to the assets it created. And three, AI is assigned a legal competence, and then it receives the rights to the assets which it has created. Now, let us cover very briefly the arguments pro and con offered, and what would be the effect when we're talking about providing protection to such assets. Pros. The main argument is that these assets created by neural networks already have a certain artistic and utilitarian and economic value. And they are already competitive to what humans make. Two, this will encourage developers of AI to develop AI further and to create something new. Argument number three is that legal protection will offer a real economic value because it will introduce these persons of law into commercial turnover and monetize their outcomes. Cons, they're quite obvious. We discussed them many times today. It's just a tool, not more than a tool, which is programmed by the creator, and the community doesn't need any incentives to work. It works in any situation. Two, unlike humans, protecting AI works can demotivate people from making this, because computers will be easier, will make it quicker and cheaper. We all know, for instance, of this case of robots that can already write headings for newspaper articles or generate images. And what Victor said, protecting such assets can steal money from existing performers. Now, let us still try understanding what really requires protection, why we're raising this issue. Let's find a balanced approach. First of all, I would like to focus on the subject of protection. In other words, what assets we would like to consider as those that need to be protected. Now, this slide, I will show you filters in Adobe Photoshop, and we can see how the neural networks can change the image with a very good quality and very significantly. But still, it's just a tool where a human decides the extent to which in which to use a particular filter. So, can we say that this is an asset created by AI? I don't think so. I think that the existing mechanism of legal protection provided by copyright is capable of solving this issue quite successfully. In this respect, neural network, AI, is yet another tool, a very progressive one, but still a tool used by humans. Again, as Victor has quite correctly said, we need to see who is guiding this creative idea. In my opinion, this is the human, so we don't need any additional protection mechanisms. Let's have a look at another slide. Here we see a different case. These are pictures drawn by Alice, our computer assistant. I asked her to draw a picture with the sea, with the cat, and the landscape. And you see the software drew it without any further guidance on my part. Can we be talking about new assets that need protection? In my opinion, yes, we can, because creative participation from human, from me, in this respect, was lowest possible. Basically, I just pressed the button. Well, the problem, as we said many times, there's no author. This is why there's no creative work of a human. Therefore, we don't have a person of law. This means that this work of art, I think we may call this a work of art, does not require any protection. Possible protection would be provide special sort of protection. This slide shows the current regulatory framework in the Russian Federation. I covered this basically. Now, I would like very briefly to outline the position with respect to the term of protection. As I said, AI does not have and cannot have any economic incentive. It is not an independent person of law. It does not require any means of subsistence or any means to create. This is why it would be logical to offer any incentives. AI doesn't need to subsist, doesn't need to feed its heirs, so it would be logical to be talking of a shorter term of protection. That said, while AI does not have any economic interest, its creators would like to receive a return on investment. Therefore, they do have such an interest. Therefore, I would like to repeat myself, we could be talking of shorter terms of protection for such assets. Now, trying to find a balanced approach to these issues, I think that most probably the purpose of such protection is in the area of combined rights approach. And talking of investment protection, we could be talking about the rise of database creators. This mode has existed for more than 20 years in Russia and the EU, for instance. Now, to sum up, I can say that, as I hope I've been able to demonstrate quite successfully, works of art created by neural networks do have artistic and economic value. I think we should differentiate between something created by humans, by creative human work, with AI as a tool, and something which do not involve human interference, where the human just hit the button. And in the first case, we need to offer protection based on copyright mechanisms. In the second case, the latter case, we probably could think of a new mechanism, a new framework that would be able to protect the interests of the developers of AI. Thank you very much. Alexander, thank you very much for being very informative, but also very punctual. I would like to give floor to Ruslan Budnik. Yes, hello, dear colleagues. A very interesting contribution. I would like to touch upon the following topic: the authorship replicated in itself. What do we think about the practical implementation of AI? Is it a supercomputer that sometimes offers us holograms as an interface? This is what we think it is. But, you know, and it has certain robots, certain drones that act as its hands, right? But, on the other hand, we have a different approach. We can be talking about convergence between a human and a computer, and based on AI technology. The thing that we already see some features and characteristics which humans have, which at the level of present-day computers are still not attainable for computers. For instance, creative abilities, not just compilation, not just some results of certain algorithms settings, but really making something which is totally new. It's just an example. And in this case, humans can do better. Although humans don't have such strong computational capabilities, they don't have this memory, but still there's a field for complementation. All senses of fusion, for instance. How can present-day robots move? They play soccer. It is quite clear that this integration module, this filtration, this data processing, and this data fusion works better in humans. So, in this way, it seems to me that this concept of convergence between humans and AI technologies has good outlooks. My second statement is that we already have something in real life. And I'm referring here to attempts of replicating, of digital emulation, of modeling, of communication, communicative abilities of a human at a very basic level. But if we look on, we will see their development. We can well expect a full-scale modeling of a person's nature, of a personality in general. We see that Google Brains and Microsoft Digital Mortality and startups have already been dealing with this, have already been attempting this. Although there's this replica AI startup, for instance. So what do we see? This process will not be happening tomorrow. It's already underway today. We're not at the superintelligence level yet, but if we talk about initial replication level or digital personality emulation, we are already there. We already are forced to work in the conditions of present-day digital reality. Well, clearly, we can well reduce this to zero, we can create something new, but most probably this process will start growing in evolutionary way. In 2016, a certain techno-blogger, a techno-journalist, made this experiment together with his father, who had fourth stage cancer, they trained a neural network using technical patterns that were characteristic of his father. Furthermore, they fed certain other data to the neural networks, what the person had been reading, writing, and they received quite satisfactory results, all the way to the wow effect. Wow, it speaks like my father. So what can we see? Well, quite obviously, experiments of this kind and future products of this kind will be based on a certain written software. You can call it an OS of a digital human, of a replicated human. And how can we see this? This software is definitely involved, but even more so, it is involved in the final result to a great extent. The pieces of this software, pieces of this code are replicated, are used in the final result. So what do we get as a result? We get a certain result, a certain object, which is related with the backbone technology, with this OS, in a way that you cannot differentiate between them. So whether we like it or not, we must be able to qualify this something from a legal point of view. So what sort of an object this is? Is it an image generated by this initial software? Then all belongs to the owner of the copyright to the software. Or is it a derivative? Because a significant part of the code was taken and is now involved in the final object. But a derivative of this object, it's an object, is an asset which has its own copyright, or a totally independent asset, totally independent subject, and the owner of the software, of the iOS, doesn't have any rights to it at all. Now, this is a question which needs to be tackled already today, because experiments of this sort are already underway. They are going on, and their number will be snowballing. Now, if we look at what it takes from the legal point of view, to see this balance moving to balancing the rights, to replicated object, see it move towards the customer, because I can myself be the customer, the person lodging an order for this, because a balance in legal terms. Well, what do we need it for? Clearly, in addition to technology ownership, the owner of rights, the copyright owner to the platform, can control the platform, can command the platform what it should take, even if we are not talking about abuse, about evil intentions. Still, we see that this object is closely related to the backbone technology, and it starts depending on it to a great extent. And this is a problem. So, to move this balance, let's look to the right. If the derivative of the initial work, this is where I start, if it's replicated, then for this derivative to be qualified as such, it has to have a significant level of novelty. I will focus just on this. Now, to ensure this level of novelty, it maybe would make sense to take this personified data set, or you can call it a database, because the object is already there. It already exists in the legal framework of today. So maybe we consider it an independent person of law. This will help us to shift the balance to the balance of rights to the resulting asset, resulting object in the favor of the client. Clearly, an AOS can be alienated from somebody who has enough money to own it. Or you can buy it. You can buy the AOS together with the entire team. Now, to sum up, I would like to say the following. Maybe this personified data set, the personified database, that will help to train the neural network to assign it with personal characteristics of a particular person or a particular human. Maybe it should be recognized as an independent owner of copyright, then it will increase the independence, the autonomous, the free will of such objects. Thank you very much for this excellent speech. We'll have the next speaker, Dr. Professor Peter Georg Picht from Switzerland, as far as I see. And Dr. Picht is professor of Center for Intellectual Property and Competition at the University of Zurich, and affiliated research fellow at the Max Planck Institute for Innovation and Competition. Herr Dr. Picht, bitte. Ja.
Thank you very much. I hope I am visible and audible. It's a pleasure to speak here today. I am speaking here today also in my capacity as a member of the Swiss national delegation to the WIPO consultations on AI and IP. And with that slide, I would like to highlight that the Center for Intellectual Property and Competition Law at Zurich University, of which I am the chairman, is actually running right now a research program and project together with the Swiss Patent Office on AI and IP. You see a couple of topics that we are addressing in that project here on the slide. So each form of contact or support to this project is, of course, very welcome. You know, I think when I come to the topic of today, I can rely on many things that have been said before by my excellent previous speakers. When we look at the practice of acquiring IP rights, applications for IP rights right now, we can identify a lack of disclosure of AI involvement. Particularly when it comes to patent applications or design applications, it's frequently clear that there must have been some AI involvement that's not disclosed. And some of the intangibles generated by AI are not actually attempted to be put into an IP right. So we can also diagnose, and that has been pointed out by WIPO, for example, as well, can diagnose something like an evasion into know-how. Part of the reasons for this is probably that firms see a certain risk disclosing their AI without knowing that actually they can still acquire IP protection. There is much discussion on whether intangibles generated or code-generated by AI systems can be protected by IP rights. Personally, I think that this is a legitimate discussion, but it should not be based on traditional notions of authorship, for example. It has already been pointed out very, very rightly today that most of the AI systems used today are basically tools. So their employment should not alter the availability of IP rights, but also as we move towards more autonomous AI creatorship, as I'm sure we will be doing, we need some system for protecting the outcome of the activity of such AI, because these outcomes, the intangibles generated by the AI, can have, and this has already been said as well, can have tremendous economic value. So I think that the discussion moving forward should not focus too much on traditional notions of authorship, but should be more ready to understand IP ownership as a functional concept. It is about assigning the entitlement to an intangible product to somebody, and I'm very much in favor, as my co-speakers, to not assign it to the AI as such, but to, you know, one or several humans having generated the AI or employed the AI. I think it may be conceivable to link ownership of such IP rights to some sort of disclosure of at least of the use of the AI, maybe even of certain elements of the AI as such, so as to, you know, broaden knowledge on these valuable systems in the market. Certainly, the person who uses an AI system at the point in time at which the intangible output is generated has a certain claim to rights on that output, but that need not necessarily be an exclusive claim or ownership. for example, persons having trained the AI may also have a co-claim, as it were. I think this is a point we have to further work out. Very importantly, it has already been pointed out that we need a framework, a legal framework in this field, which is global, not only national, because for one reason, the business models behind the generation of such intangibles are frequently global ones. So it's not national approaches are no good. And also the framework must be coherent with other elements of the legal order of the jurisdiction. And of course, data rights are very important in this respect, as AI feed on data and generate data. So I also support the notion that access to data can be an important element of a workable framework for intellectual property rights on AI systems and the output they generate. The overall purpose of the framework, the legal framework for AI and IP rights on their output should be to generate dynamic efficiency, high levels of innovation, thriving business. At the same time, while dynamic efficiency, and fostering innovation can lead us towards granting access to AI systems and their outputs, we must also not forget to incentivize the people or the firms employing such systems or building them by securing to them a sufficient reward for their innovative activity. So it's really very much about a balanced system between access and protection / incentivizing rewards. This is complex, but it's nothing that must frighten us, because we have decades of experience now in very complex IP settings. For example, standard essential patents and their front licensing. We have decades of experience on how to try to balance these goals of an appropriate legal framework. So I am also with my co-speakers who underlined that we need not necessarily invent an entirely new IP framework from scratch, but we have much experience and very good elements in our existing legal frameworks across the world, and we need to develop them onto a workable IP right system for AI-generated intangibles. So that would be my contribution. I hand over to my next speakers. Thank you again for inviting me to this event, and maybe we can be in touch in the framework of our research project. Thank you very much.
Thank you so much, Dr. Professor Picht. Our next speaker is member of ICC Commission from China, Senior Patent Council, Baidu Online Network Technology, Jia Men.
Hello. Can you hear me?
The floor is yours, and we have.
Hello, this is Jia Men. Can you hear me?
Therefore, 8 minutes would be ideal. We can hear you well.
Hello? Hello?
Please go ahead.
We can hear you very well.
Okay.
You can go ahead with your presentation, please.
So, can you see my screen?
No.
Oh. Excuse me, is my turn now?
No. You have to share it.
Sorry. Oh, I can't hear you. Oh.
Maybe you proceed with presentation.
Stop share. Now it's my turn?
It's your turn.
So it's my turn?
It's your turn.
Yeah. Okay. And can you see my screen?
Загрузите ее. We just have your presentation. If Please start your presentation.
Okay. Thank you.
Это было сказано уже 12 раз. Это было сказано уже 12.
So can I start with my
Mrs. Mann,
presentation?
please start.
Okay.
Может быть, вы выведете следующего, пока я позвоню.
Okay, I'll start now. You can hear me?
Yes, we hear you well.
Oh, okay. Thank you.
You have
Okay.
8 to 10 minutes, Mrs. Zamin.
Yeah. Okay. It's great pleasure to attend this conference. And my name is Meng Jia. I'm from Baidu Patent Department. And my topic today is new opportunities and challenges with the right holder of AI output. Now, please allow me to introduce Baidu company, maybe in 2 minutes. Baidu is a member of the ICC China and is a leading AI company with a strong internet foundation. It is one of the few companies in the world providing full-stack AI technologies, such as AI chips, software architecture, and applications. With its mission to make the complicated world simpler through technology, Baidu continuously promotes technological innovation and is committed to becoming the world's top technology company that best understands users' needs and promotes user growth. Baidu gives full use of AI technology to its products, including its platform business, like Baidu Brain, which is the only software and hardware integrated AI production platform in China, providing over 273 core AI capabilities. PaddlePaddle deep learning platform is the core foundation of Baidu Brain and is China's first industrial-level deep learning platform with full open source and complete functions. It has 4 leading technologies: developing convenient deep learning framework, super large-scale model training, high-performance reasoning engine, and industrial-level open-source model library. There are 2.65 million developers joined in PaddlePaddle up to the end of 2020. Baidu's Apollo autonomous driving platform is the largest open-source autonomous driving platform in the world. At present, Apollo has built 3 open platforms, which cover autonomous driving, vehicle infrastructure cooperative systems, and connected vehicle solutions. Now, come back to the topic. Who is the right holder of AI output? After reading all the questions in the agenda, I realized that maybe this session is more about copyright. Then I thought I could talk about the technical contribution of each participant of AI. I guess everybody may agree that the technical contribution should be an essential factor to determine the right holder. In order to understand the contribution of AI participants, I talked with some colleagues in research and development department in Baidu. Some of them are authors whose papers were accepted by top conferences. They told me many technical details, but I'm afraid I can only get and describe a small part of it. Generally, there are three main participants: the algorithm developer, the raw data provider, and the sample provider. The algorithm developers design the neurons of neural network, the connections among the neurons, and the activation functions. In other words, the algorithm developers design the structure and algorithm of the network. The raw data providers provide raw data such as pictures of cats, video with vehicles, driving test data, and so on. The sample providers prepare samples, including cleaning and transforming raw data and having data labeled. The sample providers often label the data based on the requirements from the algorithm developers. Fine labeling can maximize the effect of the samples. Sometimes feature engineering is needed to maximize the data feature. Sometimes, or most of the time, the algorithm developer and the sample provider are the same person. As mentioned above, algorithm developer decide the structure of the network, whether the network is linear or nonlinear, as well as other essential factors of the network. Raw data collection relates to raw material contribution instead of technical contribution. There are two kinds of effects of samples on the network. One is only on parameters, like the weight of the neurons. The other is also on the number of layers of the network. One of my RD colleagues told me a simple analogy. Algorithm developers draw a path to the target, and good samples ensure that the path can finally reach the target. The whole process of path adjustment is the process of training. To sum up, in my opinion, the ranking of the technical solutions, the technical contributions is algorithm developer, sample provider, and then the raw data provider. So what are the criteria to determine the right holder of AI generated product? I think from original intention of IP protection, this criteria should be helpful to protect the enthusiasm for technological innovation. So technical contribution should be an important matter. Okay, that's my point. Thank you very much.
Thank you so much, Ms. Min Zhen, for your contribution, and we go on with our presentation. And the last speaker for today is Vadim Privalov, Director of the Legal Department from Inotech Company. Vadim, over to you.
Thank you very much. Can you hear me? Yes, all is very well. Vadim, we can hear you very well. Please go on.
Just a second.
Just a second. I'll turn the volume down. Now, dear colleagues, thank you very much for your excellent presentations and for very well-grounded theoretical views. Now, usually discussions of this kind, when we're talking about AI creative work, we can hear the statement that the results of AI creative work must be protected. We hear two arguments. One, people ask whether the results of creative work need to be protected because books must be protected, works of art, music, and we're talking here about robots. And the second argument that we hear, we must encourage the interests of human authors so that they can create these works of art, science, or music. Will assigning a legal competence to robots infringe on their interests, and they would start creating less as a result? Now, to answer this question, I decided to look at it from the point of view of our opponents and to use an example. I wanted to look how this works. Now, if we look from the point of view of the current legal framework, we see what is protected by the existing copyright. There are two main criteria for protection. This must be a work of creative art. It must be made by humans. And clearly, the second criteria prevents us from protecting works created exclusively by AI, without any human involvement. But that's all very well, but this brings us back to the problem of how many drops do form a puddle, or how much human involvement do you need to be able to say that this work has human involvement and must be protected by copyright. Now, this problem came to existence a long time ago. Even when the very first programs started to appear to change computer images, people started to discuss, if I use a certain software, let's say Paint, instead of a brush, will this be protected? Or if we're changing a photograph, at what point in time will the filters change the human contribution? Back in the 1990s, an average image processing software looked something like that. Clearly, to get the final product, you had to use a lot of effort, including creative efforts. Back in the notes, programs started to change. And let's say a conventional application or a mobile app is much simpler. Now, if we think of an app in 2010, it looks even simpler. Today, many applications process images but hitting just two buttons. You just select an image, you press the button, and there's magic. It is processed in one way or another. But still, it involves human activity. You need to select the image that will be magically processed. But as late as this year, maybe last year, we started to see other categories of images that are installed on your computer, and the computer does the rest. You just hit the button, and AI does everything for you. And you receive lots of beautiful pictures as a result. Now, coming back to our situation, which of these scenarios sees that we don't have any work created by humans, and we start to get something created by AI? As a result, we lose copyright protection. There's a big number of researchers. The most well-known of them is the IPRs Association. Its meeting was held in 2019, and they outlined their position as follows. They said that as soon as human factor disappears, at least with respect to the object of human efforts, you cannot say anymore that a human created this image. In some countries, the red line happens even before that. And you need to make certain steps for this work to be considered not simply a work, but a creative work. But some countries stop at this line. Now, as a result, what do we get? We must definitely have some sort of human involvement in creating this work of art, otherwise it will not be subject to copyright. A pussy created by AI and a pussy created by a human will fall under different legal modes. The first one can be easily printed on your T-shirt. The second one requires a copyright from the drawer, from the painter. So, what does this imply? We'll have this approach. There's a certain set of initial data, AI, this black box transforms everything, and we'll have a certain end work. And since there's no human involvement, in most countries it will not be subject to copyright protection. As a practicing lawyer, I can say that it will lead us to a very simple question. Any startup that wants to use AI will say, what can we do? We want our results not to be copied. How can we change this approach so that we can apply to court and we can protect our T-shirts with these pussy prints? And the solution will be simple, very simple, and this is what most practicing lawyers said with whom I've had discussed this. They say, let us here at stage one first have some sort of human involvement, somebody who's hitting the buttons and saying, select this image and not that image. This human will do no other work, will not add any value, it will not be creative work, it will be regular work imitation, so that we can show human involvement. Because if we don't have any human involvement, there will be no copyright. Maybe this is not critical for the creative industry, where monetization schemes are slightly different, and they allow to get some sort of economic effect. But I anticipate that this can cause problems in the area of industrial design, in the area of patents. Because patents based on AI work can most probably be more effective, can look better, can have a greater wow effect, can cause more interest from consumers. But it can be copied because the law says that the design must have an author. The same applies to inventions created by AI, because there must be an author somewhere in the link, in the chain. So the question whether we want to encourage imitation of creative work instead of real creative work brings us to the conclusion that maybe if we find a mode to protect something that has been made using AI, we'll be in a much better position to help humans stay real authors, because they won't have to hit the buttons just to be considered authors in this chain. All right, the idea I've been hearing throughout the reports, I've been hearing about this film with Johnny Depp. I think we have had a very successful session. I'd like to thank all the participants. I'm Natalie Glover, managing partner of the practice of government regulation of IP at Media Technologies. And we will now listen to a stunning session on AI analytics with Oleg Yana. Thank you very much.